Thank you, and good afternoon. It's lovely to be in person at the ADR Centre. One thing that I really enjoy about being a disputes lawyer is helping clients solve problems. And in terms of some of those most challenging problems, few things can be more challenging than discovering via email or in a news article that a company you're working with has been placed in administration, receivership, or liquidation. In the construction sector in particular, when a company is involved in a live project and it collapses, things get complicated for other people in the project very fast. This is often when I step in, and one thing that my experience has taught me is the need to assess your position really quickly. Legal issues at the intersection of construction and insolvency are complex. There's little margin for error. And when I look back at projects that I've become involved in, I do recall a non-stop weekend in particular assisting a developer who had a major project underway with Arrow as the head contractor. As many of you will be very aware, Arrow quite rapidly and suddenly folded. Time is money in construction, and what we were working to do over that 8 hours is to identify what our rights and what our priorities were. In that case, where we came to was that a key priority was calling a bond and also negotiating with the administrators for access to resources that we currently didn't have under our control, so that we could, as soon as possible, continue the project with alternative contractors. So what that example reflects to me is that the first 48 hours really matter. And it is essential in that period for you to really and quickly understand the nature of the insolvency process which you are dealing with. Each insolvency process, be it, for instance, receivership, administration, or liquidation, is different. The people running these processes have different duties and they have different goals. Familiarity with these processes, the duties and the goals, provides you a strategic advantage and a head start when you find yourself in the position of dealing with an insolvent counterparty. So today's first goal is going to be helping you become familiar with some key insolvency processes so that when the worst happens, you're able to mitigate and manage the risks to your company. I want to help you learn about these processes through using some real life examples. It's, of course, the collapse of a head contractor. Like probably many on this call, I worked on aspects of this collapse. But what I want to stress at the outset is that what I'm covering is drawn from publicly available information. I'm not sharing any client secrets. I've also changed some names. I don't like talking about people's worst days if I can avoid it. And it allows us a little bit of editorial license when it comes to building up the picture. So for today's case study, I'd like you to assume that you're a member of the body corporate of a development which we'll refer to as Weber Towers. That is a fictional name, but I've drawn their story from some real events, and what will happen to us as Weber Towers has some parallels to what happened to a real company. So your building has suffered from defective construction. It has had problems with leaks, including through the common property, and you've been working for a number of years in terms of solving that issue. Things must have seemed to be on the improve in 2011 when you signed a construction contract for remedial works. When you selected your head contractor for those works, you would have had some comfort that you were partnering with one of New Zealand's largest and most established construction companies. And by February 2013, work was actively progressing. Notably and importantly, you had 2 large hoists on your construction site. They were crucial for accessing different building levels in the continuing works. Then we moved to Waitangi Day 2013. And some bad news. You received notice that receivers from PwC have been appointed to your head contractor, Mainzeal. What you find out subsequently and in the news coverage is that the Mainzeal had breached a banking covenant. All but one of its directors had resigned, and the sole shareholder requested its bank to appoint receivers. Now, in the notice that you sent by PwC in relation to the appointment of receivers, you'll see that it said that they're appointed pursuant to their appointing creditors' power under their security over all present and future assets of Mainzeal. And indeed, if you had searched the Personal Property Securities Register, you would have seen that there was a registration in favour of a bank over all present and future assets of Mainzeal. And what that reflects is that the bank had a general security agreement, or GSA, over Mainzeal's assets and its business. A GSA is the linchpin of secured financing in New Zealand. It is having a first ranking registered on the PPSR. GSA is a very powerful and important tool for a bank or other lender to be prepared to lend significant sums of money. And what it did in this case was to give the bank the ability to appoint receivers to take charge of the assets and business of Mainzeal. So those receivers, like all receivers, are appointed on the basis of 2 things, or with reference to 2 things. First of all, it's the power that appointed them, and secondly, there will be rights and obligations under, in particular, the Receiverships Act. In the case of most receivers in New Zealand, the power under which they're appointed is contractual, usually in the form of a GSA. So the General Security Agreement in this instance would have given the creditor the ability to appoint receivers over Mainzeal. And then there are primary and secondary statutory duties of a receiver which are set out in the Receiverships Act. On a primary basis, a receiver needs to act in good faith and for a proper purpose, and they must exercise their powers in the best interests of the appointing creditor. That is important. Secondarily, as a secondary duty, they must have reasonable regard to the interests of the company and its other creditors. So what does that mean for you as the body corporate of Weber Towers in our example? What that means is that the receivers need to prioritise the interests of the secured creditor who appointed them. So the immediate actions of the receivers, as they would have affected you in this case, would have begun, as they so often do, with first of all securing the construction site. They need to make sure that things are safe from a health and safety perspective, and they also have to secure the site to prevent, for instance, subcontractors engaging in self-help and taking assets away from the site before the receivers have had the opportunity to determine who has entitlements to those assets. So you may have gone to your site on the day of the appointment of the receivers to find it closed and secured with security personnel there. Next, early steps of the receivers would move on to allowing subcontractors to retrieve their tools and equipment where they have proper records. And most relevantly for you in terms of your commercial position going forward is that they need to evaluate the active projects. In the case of Mainzeal, there was something like 42 active construction projects. And so the receivers in their first report noted that what they were doing were analysing ongoing projects to determine whether they could be continued and to work with the principals and the other parties involved in those construction projects. So you'd see receivers in that instance engaging with you as a principal. And in those engagements and in approaching and understanding the nature of any negotiation with the receivers, you need to bear in mind what considerations need to be front of mind for the receivers, remembering what their primary duties are. They have a primary duty to act in the best interests of their appointing creditor. Maintaining the survival of your project isn't a statutory primary duty for them. So understanding quite early what the viability and attractiveness of continuing your project might be from the perspective of the secured creditor will be important. There are instances where a receiver will form a view that it is in the best interests in terms of a best outcome for the appointing creditor if a construction contract is completed. But what they need to consider are the costs, risks, and potential returns of any type of continuation of the project. Receivers only have a duty to have a reasonable regard for your interests as another creditor. You are not a priority as Weber Towers. In the case of Mainzeal, in the vast majority of projects, it was decided that it was not viable to continue with the projects. And so you should, or you would have received a decision on about the 20th of February, in this case from the receivers, that they were not going to continue with your project. So where does that leave you as Weber Towers? What you may well have done in that instance is quite quickly taken out your construction contract with Mainzeal. If you looked at that contract, you would have seen it written on the page that you had the right to terminate the contract if the receivers didn't take over the work or make satisfactory arrangements for its continuation within a short set period. You would have seen that you would have had the right to resume possession of the contract works and on-site materials under the contract. And you would have seen it specifically written in your contract that you had the ability to complete the project using existing materials and equipment, that you had the ability to recover reasonable costs incurred in completing your project, and that you could at the end sell any surplus materials or fittings, applying the proceeds against the contractor's liabilities. So having a look at the words on the page, you may have thought, well, actually, look, things look quite good. And understandably, given the insolvency of Mainzeal, you'd take a decision to issue a termination notice. And at that time, you assert that you have a lawful right of possession to assets on the site, notably the two hoists, which you'll see sort of indicated, for example, on the slide. However, if you assumed that what was written in your construction contract and what read on the page reflected your rights in an insolvency context, that would have been a mistake. There is a dimension shift when a company goes into an insolvency process, which changes the context and often the nature of your rights as a party who has been dealing with them. Before insolvency, key sources of rights for you as Weber Towers would have been your construction contract and, for instance, the Construction Contracts Act. However, the moment that Mainzeal went into receivership, perhaps the most important sources of law and of rights become the Personal Property Securities Act and the priority rules under the Receiverships Act and the liquidation waterfall. So your claim to the key hoists and other assets under the contract, the receivers, when they received your notice, might have written back and said, well, actually, you're wrong. Your right to take possession of the hoists is, in fact, a security interest. Because it's a security interest, that means that the priority rules under the PPSA apply. And as a result of the operation of those rules, the bank's registered security interest takes precedence over your interest. In this situation, the receivers were able to go to court and get directions from the court, which affirmed that they had control over the hoists. So what this does, in terms of an example, is really highlight the need to understand the broader legal context of insolvency when you are considering your rights. It's also a good example of the importance of getting timely and specific advice on the impact of insolvency on your existing contractual rights. And a good example of remembering and recognising the duties of receivers. Again, they have to act in the best interest of their appointing creditor, and their appointing creditor has a legal right of priority in this example. I mentioned the insolvency waterfall when talking about the concept of priority. And I think it's important just to dig a little bit further into that concept. In your position as Weber Towers, because Mainzeal has breached its construction contract, you would assume, well, I've got a damages claim against Mainzeal for breaching its contract. In terms of what your prospect is of getting paid for the losses that you've suffered as a result of Mainzeal's default, you need to understand the waterfall and who gets paid first in insolvency. This knowledge directly impacts your chances of recovering losses and informs your strategy when you're dealing with a counterparty that's in an insolvency process. So in terms of this process, receivership and liquidation costs are paid first. Then there are two classes of creditors who have priority over others in New Zealand. So taking the example of Mainzeal, we had secured creditors. Now, there was the appointing creditor who appointed the receivers. They had a first ranking general security agreement. They got paid. The receivers continued to run the company and recover assets and were able to repay the appointing creditor. Also, a number of suppliers who had registered something called a PIMSI. Now, a purchase money security interest is a very powerful way of getting super priority in terms of rights to personal property. So that is, it's got to be things which are movable. We're not talking about buildings or things which have been incorporated in buildings. But for instance, if you are supplying materials on credit, then at law, you have an ability to document that arrangement in a way that gives you a purchase money security interest, and then provided you register that interest promptly, and that is generally within 10 working days, then you have a right of super priority to get paid you have a right of super priority over what you have supplied in this case, in the receivership of Mainzeal. So working with your construction lawyers or your ordinary lawyers in terms of understanding whether there is any kind of equipment financing, any aspects of supply in terms of your business, any retention of title which means that you could have a right to a purchase money security interest, is really key in the construction sector. So getting the advice over what could be a PIMSI is very important, but also making sure that you have processes in place to make sure that they are always registered in time is just as important. So PIMSI holders got paid, the first ranking security holders got paid. So that's secured creditors. Other creditors, in the case of Mainzeal, who had a special status, are types of creditors who have what's called a preferential status under New Zealand law. Examples of those are employees with regards to certain of their entitlements, the IRD with respect to PAYE and GST. But if you're not a secured creditor, if you're not a preferential creditor, then everyone else is an unsecured creditor. So as Weber Towers, with your claim for damages, because you have and will suffer loss as a result of Mainzeal collapsing, your claim in the insolvency of Mainzeal is as an unsecured creditor. And a really key concept underlying all insolvency processes is the principle that unsecured creditors of a company share equally in any entitlements that might be left for them. So this is what's called the pari passu principle. And I will come back to that. So what are your options as Weber Towers? You've suffered loss as a result of Mainzeal folding. How do you recover that? As I've mentioned, you could make a claim for damages, but that would be an unsecured claim. And its prospect of recovery depends on how much can be recovered by the receivers, or in this case, the liquidators who took over. Interestingly, if you had a performance bond that had been issued by a bank or by an insurance company, you might be able to call that. And that's because usually a performance bond is not a contract in this instance between Weber Towers and Mainzeal. As far as Weber Towers goes, your performance bond is a contract between you and the bond issuer. And what would have happened if you had the ability to call your bond in receivership or liquidation is that if you called the bond, you could be paid on that, but the person who issued the bond would then have an unsecured claim, or depending on their arrangements with Mainzeal, would have a claim in against the estate of Mainzeal. So this waterfall became particularly relevant in the case of Mainzeal, because any hope for Weber Towers of things turning around for Mainzeal was diminished when liquidators were appointed less than 3 weeks after the receivership began. Liquidators were appointed by resolution of the shareholder. Liquidation is the process of winding up a company. A company, receivership does not always lead to liquidation. Sometimes receivership can be used to effect a sale of a business as a going concern. But in the case of Mainzeal, liquidation followed quite quickly. What that meant in terms of day-to-day dealings for you as Weber Towers would have meant initially little because the receivers continued to act as agents for the company by agreement of the liquidators. And very often where you see receivers and liquidators appointed over a company, it is the receivers that you will be primarily dealing with. So as I mentioned, liquidation is underlaid by this principle of equal sharing. It's a collective process. In the liquidators collect and distribute assets among unsecured creditors after paying the preferential debts. And the impact of liquidation is that the ability of any individual creditor to take enforcement action against the company is automatically stayed by operation of law. And the reason for that is it's not about who gets in first in terms of trying to enforce their rights to payment. It's about a collective process which is overseen by a liquidator in accordance with principles set out in the Companies Act. So key principles for the liquidation would have been maximising returns to creditors, and applying a fair and equitable regime based on this equal sharing principle. And because of this principle of equal sharing and because liquidation is by law a collective process, there are a number of provisions and procedures in our law which allow liquidators to effectively look into and in some cases unwind transactions that were made before the liquidation, which broadly would have had the effect that meant that one creditor got an unfair advantage over another. And so these are things like voidable preferences. And what that means in short is that when you have doubts about a company you are dealing with, about whether they are solvent, if you're hearing rumours about them, and you are concerned that you need to do something to improve your position, that is a point at which it's important to quickly take some legal advice to understand whether with anything you are doing, there is a risk of a liquidator later being able to claw that back, and whether there are other ways that you could protect yourself in your particular circumstances. So the liquidators in the context of Mainzeal recorded in their reports that they began by investigating restructures of the business that had occurred, some related party transactions, the solvency of Mainzeal at various times, and of course, the actions of directors. And that brings us to what will be my final chapter in terms of the Mainzeal narrative. And that is the chapter which sees us move into court. But first, actually, a quick side note. Since the Mainzeal experience, we have seen more use of voluntary administration in the construction sector. It was used in the Arrow example that I mentioned. It's important to understand a little bit about voluntary administration, and that is that it is a potential corporate rescue tool. It's intended to give companies breathing space. It allows an administrator to step in and run the business and investigate whether there is a restructuring which could save some or all of the business, and whether that could be agreed between the creditors of the companies when put to a vote. It is very useful in the context of a head contractor, for instance, because by law, when a company goes into voluntary administration, a principal, so someone in the position of Weber Towers, would be prevented from resuming possession of the construction site. Similarly, they couldn't take any other enforcement steps against the company. This is for a limited breathing space period. Once it gets past about 20 working days, it's subject to court supervision. Voluntary administration is a corporate rescue tool. It has, in the last couple of years, been used very successfully in Australia in relation to a couple of very substantial head contractors. The projects were kept running under the administration period, and effectively parts of the businesses were sold or restructured. We've used it successfully in New Zealand to restructure the debt of an irrigation scheme when faced with an adjudication claim that could not be immediately met. So moving then back to the end of Mainzeal and my final points. The liquidators famously brought actions against the directors of Mainzeal, and their claim against the directors went all the way to the Supreme Court. And what that means is that we now have very up-to-date guidance, which is about a year old, from New Zealand's highest court, which sets out what the court's expectations will be of directors in terms of managing or governing companies which are in financial difficulty. It's what's often referred to as the twilight period. So briefly, in the Mainzeal case, it was found that the directors breached Section 135 of the Companies Act. So particular issues for them in that case was that they continued trading without sufficient capital or reliable financial backing and failed to address the risk posed to creditors. And so that related to a breach of their duty not to allow the company to operate in a way that risked serious loss to creditors. They also breached their duty in regard to the obligations that the company was taking on. Mainzeal entered into major projects after January 2011, and it was found without reasonable grounds to believe that the obligations could be met. And the court, looking at the facts, concluded that by July 2012, it was clear that the company couldn't resolve its issues. So in terms of the guidance that came from the court, there's been a lot written on this, and all of your lawyers will be able to share this with you if needed. But what is key is that when you are faced with a period in which you have concerns about the ongoing viability of your company, whilst you're allowed a reasonable time to assess your company's financial situation, you need to make informed decisions about whether to continue trading. It's very important to seek seek specialist advice and to seek that early. If there's a substantial risk to creditors, you must act promptly. It may be acceptable to assess options and develop a recovery plan, but you need to be very careful to ensure that there's no additional risk imposed on creditors. But trading in the long term in a context in which you are for instance, balance sheet insolvent would generally be unacceptable. You need to have concrete, reliable financial support. And the longer that the company trades balance sheet insolvency, the greater the potential risk and liability to you as a director. So I'm just going to hand over at this point to Michael at the beginning of the conclusion of this session, where with all of that context in mind, we're going to look to give some strategies in terms of mitigating your risk.
Thank you, Polly. One of the themes which Polly's spoken to is the need to act promptly, and we recommend obviously that you resolve disputes as they arise as early as possible to avoid disputes snowballing and giving rise to large contingent claims at the end of the process. We see lots of last claim disputes where issues have either been parked by the parties or they've just been unable or unwilling to resolve them during the project, and that then obviously comes to a head at the end of the project when often the contractor has therefore lost leverage because the work's been done. One of the ways that this can be addressed is through the Construction Contracts Act adjudication process, where the contractor issues payment claims that comply with the Act. You're probably aware there's strict requirements within the Act, including the requirement to add the prescribed notice to the end of the payment claim, but provided that payment claim is compliant, then there's an obligation, the obligation shifts to the recipient, the principal, to issue a payment schedule, again, that complies with the requirements of the Act. And if that's not done within the mandatory time frame or the payment schedule is not compliant with the Act, then that gives the contractor a default right to payment. That can then be brought to through the CCA adjudication process for a determination that confirms that default right to payment. At the same time in that process, and we often see this as alternatives, the claim on the merits can also be addressed in that process as well as an alternative if the default provisions don't apply or are found not to apply. The process is pretty quick. It normally takes 35 or sometimes up to 45 working days for the determination process, and then any payments that are awarded are required to be made within 2 working days after the determination. So that's important, obviously, both for cash flow and also, as Polly touched on, in terms of the clawback periods, particularly the 6-month restricted period where the company is deemed 6 months prior to liquidation, the company is deemed to be insolvent and the liquidators can claw those payments back. And then once the determination is issued, it is, if you need to enforce it, it's enforceable as if it was a district court judgment. Move the slides the wrong way again. And then just quickly on other and all of these processes are private and confidential, of course, which is another key consideration compared to court action, the contractual adjudication processes. And there are these other processes available: early neutral evaluation, which is effectively a third opinion, which the parties can agree is either binding or non-binding. There's mediation, which is facilitated negotiation. Expert determination, which is particularly suitable for factual or technical disputes. And then adjudication in project, which, as we've mentioned, enables you to get a ruling on the merits or on payment claims in parallel with the project continuing on, so you don't have that last claim snowball effect. There can also be expedited arbitration processes. It doesn't need to be the quasi-high court set-piece battle that KCs, with all due respect to them, sometimes default to. It can be a really truncated and focused process that deals with the selected issues at question. And then finally, just for completeness, for large projects, you can have a disputes board or a disputes resolution board. Not very common in New Zealand, but more common in Australia. And that is just a process or a forum where issues can be surfaced very early in the piece and hopefully addressed before they snowball. And with that, I'll just hand back to Polly to talk further about strategies.
So the risks of insolvency in the construction chain can be divided into at least 3 buckets. The first is contractual strategies. And so this is in relation to the outset of your construction contract. In any well-negotiated construction contract, and indeed in standard construction contracts, there is quite a lot of intention given to maximising your position and clarifying your position in the case of insolvency. What I've sought to highlight today is the importance of understanding that what is written in your construction contract won't be the end of the matter, and really understanding how what's in your contract and in the protections you've negotiated will operate when there is the dimension shift of insolvency is important. It is important, as I've mentioned, another key thing is really making sure that you have taken advice on understanding how the PPSA might apply to your business, and that you also have procedures in place for making sure that, for instance, if you have the ability to register a PIMSI, that is being done in every case. So contractual strategies should really already be BAU, but each time you are in the position of entering into a new contract, it is a good time to be asking some questions of your front-end construction lawyers as to what would happen if this party I'm contracting with went into liquidation. What would my rights be? And then performance strategies. So this is what can you do when you are implementing your construction contract to mitigate your risk in the situation in which the other party became insolvent. That covers some of the things that Michael's covered. For instance, making sure that you resolve your disputes during the contract, making sure that you adhere to and use the processes that you have access to under the CCA to ensure prompt payment. You want to be paid up to date, and you want to be monitoring the payment performance of your counterparty. If you start to be in a position where you're concerned about their solvency, that's a point to take some specialist advice. That's a point at which to consider what you can do, whether there is anything you need to do to protect your position in the event that liquidators were appointed. In terms of post-appointment, that's been most of what my part of this presentation today has focused on, in terms of the importance of really understanding the process that you're in and what your rights are under that insolvency process. There are a lot of questions that you'll want to get answered very, very quickly when someone's appointed. They will include whether you have a right to call any bonds against parties that aren't insolvent, what the PPSR tells you about registered security interests. Always remember to keep following your payment claim and payment schedule processes under the contract and under the Act when your counterparty is in liquidation. The receivers or liquidators would be or are under a duty to realise assets of the company. And if you haven't put in a payment schedule in time, then that payment claim is an asset of the company, and the insolvency practitioner may be under a duty to collect that money from you. So that is a very important thing not to overlook. And you'll need to review basically anything that you need access to be able to mitigate your risk, and in the case of the Weber Towers example, continue your contract. What do you need from the receivers in order to be able to continue the project if they walked away? Do you have continuity deeds with your subcontractors? Are you going to have to pay subcontractors to keep them in the picture anyway? Will that mean that you can then claim for that in the liquidation? Are there any main Zeal employees or records that you're going to need to access to get the project completed? What are you going to do about producer statements, warranties, etc.? Who owns materials on site, off site? And finally, and always importantly, insurance. Review your existing insurance policies. Make sure you notify where you need to. So that's a very very rapid fire summary of some of the very important things that you're going to want to work through in the post-appointment period. And hopefully what we've done today is to give you some ideas so that if you find yourself in that position or in that position again, you'll have a bit of a perspective as to what might occur, and you'll know some of the things that you'll want to consider. We don't have any questions in the chat yet, so I'm just keeping on talking. But so any final questions?
No, I don't think we'll have any. So I think we might just wrap up there.
Fantastic.
Thank you very much, Polly. As I mentioned earlier, we will send the link to the recording of this webinar out to you by email, along with the slides. I'd like to thank you, Polly, very much for an excellent presentation. Thank you all for attending, and look forward to seeing you all next time. Thank you.
Thank you all. Bye.